So, good afternoon, everyone. I hope you're staying good and fine, also doing well. And when we are up with today's topic is the Personal Data Protection Bill 2019 and the issue of privacy. This Personal Data Protection Bill 2019 and the issue of privacy is one of the most debated and vigorously discussed issues in the course of politics. Okay, because the issue of privacy has become a national issue. It was earlier confined to some judicial cases, but now the issue of privacy has become one of the... Good afternoon, everyone. Good afternoon. What kind of noise? I don't know. There's no noise right now. Okay, so the issue of privacy is one of the most contentious issues right now, as the most contentious contemporary issue, because earlier we Article 21 of the Constitution of India, like, it comes again and again into the picture because it's one of the most comprehensive articles, comprehensive fundamental right. I don't know how and why this Article 21 is discussed again and again. Unconsciously, wittingly or unwittingly, we come and somewhere land on Article 21 of the Constitution of India. Article 21 simply contains, like we have already discussed it many times, right to life and personal liberty. And we have already discussed it many times that the Maneka Gandhi versus Union of India was one of the cases, one of the important cases, landmark cases, which defined the term life, which defined the word life in right to life and personal liberty. The Supreme Court said, and I'll reiterate it, the Supreme Court said that the term life here means a human being's life, and we cannot confine it to the issues of food, shelter and clothing. We have to look, if we want the real meaning of life to be construed and constructively brought into the ambit of Article 21, we need to look beyond food, shelter and clothing. Because if we are going to confine the definition of the word life merely to food, shelter and clothing, this would be no more than a mere animal existence. And that is not what the Constituent Assembly members intended. They intended a human being's life. And whenever we talk about human being's life, there are other important issues also which are as important as food, shelter and clothing. And one of the most important issue in every human being's life is the issue of privacy. We have innumerable other things also. Other things are also there, but privacy is one of the most important issues, because a person's dignity, a person's respect is protected only when his privacy is protected. Okay, every person has some private space. Every individual has some private space, and that private space is very natural. Intruding or peeping into somebody's personal space is absolutely uncalled for, or truly uncalled for, and highly unbecoming for a dignified society. So we have to make sure that the privacy of every individual is protected. So the issue of privacy was earlier, as I was saying, that the issue of privacy was earlier, was limited to some judicial decisions. If you remember the case of Khadak Singh versus the state of UP, the very first case when the Supreme Court very first time recognized and constructively brought the right to privacy and within the ambit of Article 21 of the Constitution of India. Do you remember what happened in Khadak Singh versus the state of UP? Let me tell you briefly. Khadak Singh was a prime suspect in one of the crimes. UP police was interrogating him. Okay, he was left, he was caught, he was apprehended by the police. Then he was left and left to go home because of the lack of evidences. But the UP police, deployed a personnel outside his house who would keep his, who would keep like tabs on his movements 24/7. So when already a police personnel was deployed out of his at his house to keep tabs on his movements 24/7, he got irritated because there was no personal space. His privacy was being violated. And why did the police do so? Because the UP police was empowered to do this under the UP police regulations. There were UP police regulations and the UP police was empowered to do that. Okay. So Khadak Singh then challenged the constitutional validity of the UP police regulations, and the Supreme Court finally held the UP police regulations as ultra vires the Constitution, ultra vires the right to privacy under Article 21 of the Constitution of India. And Supreme Court said, no, it does not matter whether a person is an innocent person or he is a prime suspect. Okay, it is the job of the police to collect the evidences and investigate the matter. But that is not the correct way to investigate any matter while keeping tabs on the movements of any person, intruding into somebody's personal space. That is truly uncalled for. So the UP police regulations were held ultra vires the Constitution. Okay, now Article 21 of the Constitution of India contains right to privacy. However, this right to privacy has been separately recognized under various international documents like UDHR, but we do not have a separate article relating to right to privacy. We have constructively recognized it within the ambit of Article 21 of the Constitution of India. Okay, now the privacy, like we have many other cases on this, judicial precedents on this issue, like Mr. X versus Hospital Z, like there are many other cases. But now the privacy became a national concern. The issue of privacy became a national concern nowadays, because as we have completely slowly and gradually have dwelt completely about our existence on the latest technology devices, like we use iPhones and we use Android phones, and we submit almost all our personal details to many of the things on the internet. Like we create social media IDs on Facebook, Twitter, Instagram. Okay, we submit our very personal details there. What is our name? What is our date of birth? Where do we live? What is our like our address? Even if you are not submitting the address, then your address and your location can be traced through the the IP address. Internet protocol can help trace your location also, even if you are not submitting it. But we have already submitted it on almost all the platforms, various platforms. Like we are using UPI payment modes, we are using net banking, we are using so many things. Like we are ordering things on Amazon, we are dwelling on online shoppings. Like everything has gone virtual completely. So the question was that the issue of privacy became a national concern. It is very easy for the agencies, like government agencies, who are quite witty in bringing out and unearthing the details of any person on the internet. If you are on the internet, that means you have already surrendered your privacy. You should know this, that if you are on the internet and if you have any web presence, you have already surrendered your privacy. That's it. Your privacy is gone now. Somebody would be knowing something about you. Somewhere in the world, somebody would be knowing something about you. Okay, we use GPS, we use global positioning systems. Do you know the United States of America developed this global positioning system in 1993 to cover almost all the countries of the world? And it contains 24 satellites. In 1993, US did this way back in 1993. It developed 24 satellites to cover the entire world. You take the help of the GPS. How do? You are submitting the details to somebody sitting in the United States of America. Albeit many other countries, including India, have developed their own like GPS systems, GPS kind of systems. Okay, but still we are submitting our details. We are telling people that where we are going, where we are moving, what are we doing, everything is known. Okay, so this is what is the current situation and current scenario with regard to privacy. So the Personal Data Protection Bill 2019 and the issue of privacy comes in this background, that Personal Data Protection Bill comes like as a remedy, or as a necessity to make sure that whatever personal data you are sharing on the internet needs to be protected. It should not be leaked. No agency, not even the government agencies, should be allowed to intrude into your personal space and misuse your personal details regarding against anything, to make you do anything. Okay, so this is a cause of concern right now. For example, the issue of privacy flared up in the past recent years because of one thing: Aadhaar card. I have already told you, we have already discussed this issue in the past weeks also, that the issue of Aadhaar is a very contentious issue. Aadhaar is one of the new identity cards based on the latest technology, because it is not like ration card, it is not like PAN card, it is not like bank passbook, it is not like electricity bill, it is not like domicile certificate. It is absolutely different from all the other identity cards because it contains your biometric data. It contains your iris scan and it contains your fingerprints. The iris scan and the fingerprints, they talk about your uniqueness. You have such a distinct, every person, you, me, and every person in this world who have lived and died and who are going to be born in the future and who are currently living, every individual has a different iris scan and different fingerprints. No fingerprints cannot be matched with any other person. Every person has a different characteristic of different iris scan, different nature of iris scan, and different fingerprints. So that's what tells about the uniqueness of every individual. If you're submitting your biometric data to somebody who was simply licensed by the government to collect your personal data or biometric data, this became a serious issue. Actually, the issue of privacy flared up because we were submitting the personal data, we were submitting the biometric data, the very personal information, the information of our body or the information that relates to our body, to somebody whom we didn't know. Like there was a person who is a private individual who was merely licensed by the government to collect the data and make the Aadhaar cards. That's what has been happening. We did that. We have already done that. Okay. So this became an issue, and more than 100 petitions were filed, more than 120 petitions were filed before the Supreme Court against the Aadhaar cards, and the procedure was also challenged regarding the Aadhaar card. And what happened? A 9 judges bench was already constituted by the Chief Justice of India to decide upon the nature and gravity of this right. They did not say we have to introspect and we have to look into whether right to privacy does exist or it does not exist. No, they wanted to decide the nature and gravity of this right. So the 9 judges bench surprisingly gave the judgment with the 9:0 ratio. That means all the 9 judges on the bench unequivocally and unanimously said one and the same thing, that right to privacy is an uncompromisable and uncompromisable fundamental right under Article 21 of the Constitution of India. So that is very important. Besides this, in this background, the Supreme Court also emphasized the need for bringing the Personal Data Protection Bill 2019 so that these kinds of issues can be dealt with. Now let us read what is Personal Data Protection Bill. This Personal Data Protection Bill 2019 was introduced in the Parliament. The bill was earlier referred to Joint Parliamentary Committee, and then it was supposed to come in the budget session of 2020. Now let us see. The bill seeks to provide for protection of personal data of individuals create a framework for processing such personal data, and establishes a data protection authority for the purpose. What the bill intends to do? The bill seeks to provide for protection of personal data of individuals. Okay? Protection of personal data of individuals. Whose data? Your data, my data, my personal details, your personal details will be protected by this bill. This will create a framework for processing such personal data. All our personal data will be processed and stored somewhere in a very safe place. Okay? And it also establishes a data protection authority for this purpose. And now let us read some basic key features of the personal data protection bill. What is personal data and data protection? Data can be broadly classified into two types, personal and non-personal. Like this is this is the broad classification of data, that it can be classified into two types, personal data and non-personal data. What is personal data? Personal data pertains to characteristics, traits or attributes of identity which can be used to identify an individual. I told you, like the best example is your Aadhaar card. Okay, UIDAI number that you are bearing, your identity and your uniqueness has been given a number. Okay, this number is the Aadhaar number. So it is used to identify, it contains characteristics, traits or attributes of identity. Okay, ration card was also an identity card. It contains your names, address, age, sex and everything. But it is not as, it is not as what do we say? It is not like as strong as Aadhaar card, because your Aadhaar card establishes an identity which is very unique. Your fingerprints and your irises can take for example, if the police is tracing someone. So Aadhaar card, with the help of the iris scan and with the help of the fingerprints, the person can reach the exact same person who after whom the police was, hankering after. So this is how accurate it is. So there can be confusions in the ration cards also. There can be confusions in various other identity cards also, because your names can be similar, your photographs can be similar, your addresses can be similar, your age can be similar to somebody, your age can be you can have same sex also. So but what distinguishes in such cases is your biometric data. So personal data pertains to characteristics, traits or attributes of identity which can be used to identify an individual. Non-personal data includes aggregated data through which individuals cannot be identified. Like there is an aggregated data through which individuals cannot be identified. For example, while an individual's own location would constitute personal data, information derived from multiple drivers' location, which is often used to analyze traffic flow, is non-personal data. Like we often use certain softwares, and the softwares would tell you that, like if you want to go somewhere, this usually happens in big cities like Delhi, Mumbai, Kolkata, Ahmedabad, that if you want to go somewhere, okay, what will you do? You would simply take out your phone and find out the flow of the traffic on a particular route. If your software is showing and telling that this whole route is quite swamped today and there's a heavy traffic on the road, you would take another route. Now this data which was taken by that software to tell you that there is a heavy traffic flow on this particular route is a non-personal data, because this data is not identifying the individuals traveling on that road. It is simply recognizing that there are so many people together traveling on this route, so it is better not to take this route, you should take the another route. Okay, so that is non-personal data. These softwares, they use non-personal data to tell you that there is a traffic flow, is a heavy traffic flow on this road, while Somebody's personal data would be to recognize a particular individual, like what is his name, where does he live, where does he lives, what is his age, what is his gender, and what the iris scan and the fingerprints and everything. These are like characteristics, traits, or attributes constituting personal data. So I hope you have understood the distinct difference between personal data and non-personal data. Now, what is data protection? Data protection refers to policies and procedures seeking to minimize intrusion into the privacy of an individual caused by collection and usage of their personal data. The data protection refers to policies and procedures seeking to minimize intrusion into the privacy of an individual caused by collection and usage of their personal data. Like softwares are using what? Are using personal datas. They are collecting them and they're storing them somewhere. Okay, and based on those personal data, certain policies and procedures are designed so that any intrusion into the privacy of an individual can be minimized. Okay, so data protection simply refers to policies and procedures seeking to minimize intrusion into the privacy of an individual caused by collection and usage of their personal data. Okay, so that nobody, not even the government agencies can intrude into somebody's personal space or can misuse that personal data for somebody's personal benefits, or for committing a crime, or for anything, or for using it as a threat against somebody. So data protection is simply a set of policies and procedures. This data protection bill was also a set of this came also as a part of policy and procedure, because there was earlier a committee constituted. We are going to come to know about the Justice B.N. Sri Krishna committee, that what that committee suggested. So data protection refers to policies and procedures seeking to minimize intrusion into the privacy of an individual caused by collection and usage of their personal data. So do you have any question up till here? I hope the discussion is going quite well and you are getting my points. I hope everything is going fine. Do you have any doubts or confusions? Okay, it's clear to you, I guess. Okay, thank you. Why was a bill brought for personal data protection? Now the question is, we are discussing the second caption. Why was a bill brought for personal data protection? This question is, in August 2017, the Supreme Court held that privacy is a fundamental right. Like Justice K.S. Puttaswamy versus Union of India, I discussed it. K.S. Okay, thank you Aishwarya, Chitralekha and everyone for telling me that you have no doubts right now. So I was saying, K.S. Puttaswamy versus Union of India, the judgment I discussed right now, just a while back. What did it say? 9 judges bench, ratio was 9:0. What did it say? That privacy is the fundamental right flowing from right to life and personal liberty under Article 21 of the Constitution. The court also observed that privacy of personal data and facts is an essential aspect of the right to privacy. Okay, the issue of privacy of personal data and facts is an essential aspect of the right to privacy. You simply can't limit this issue up to the point that one should not surrender his personal information or submit his personal information to anyone, not even on any web portal. It is also about the personal data which has already been there. Okay, which is already there on the web portals, different web portals, or it has any web presence, then that also needs to be protected, because we can't stop people from submitting anything online. Okay, we have to make sure, because everything is going online, everything is slowly and gradually and eventually getting virtual. Right now, even the Supreme Court hearings and the High Court's hearings have started this, that you can appear in any High Court of India and in the Supreme Court virtually. Everything has gone virtual today. Not only your classes, but also everything else has gone virtual. People and different institutions are using different softwares for streaming, for holding virtual discussions and virtual conferences. Everything is virtual, right from your local institutions to everything at the international level today seems to do, like there are various international associations of journalists. There are also International Bar Council of India, International Bar Council. That International Bar Council is also holding virtual sessions and virtual conferences. Okay, so like everything has gone virtual today. We can't stop people from submitting and surrendering their personal data to anyone. We have to make sure that whatever data an individual submits on any web portal, it has to be protected, because the protection of such personal data is an essential aspect of the right to privacy. Okay. Ankita's question is that non-personal data. You want me to explain non-personal data again? Non-personal data is simple. Non-personal data is the data which is collected for a group, from a group. Okay, like there is a heavy traffic flow on the road. This article has already cited an example. You're using certain softwares to know which route is clear right now. If you want to go somewhere, okay, you would take out your phone and you would see that which route is clear. The software will tell you that this route is very congested today because there is a heavy traffic flow. So the people who are present there, their locations were were taken out, and it was shown by that particular software that there is a heavy traffic flow on a particular road. Okay, individuals have not been recognized in this non-personal data. Individuals are not recognized in this non-personal data. Okay, personal data is that when an individual is recognized by his characteristics, traits or nature, or by any of his unique information, that is known as personal data. Okay, so the court also observed that privacy of personal data and facts is an essential aspect of the right to privacy. In July 2017, now look at this very carefully and listen to me very carefully now, because this is one of the very important questions and very important nuggets of information contained here in this paragraph. You have to understand this, because committees are very important for objective questions. In July 2017, a committee of experts chaired by Justice B.N. Sri Krishna was set up to examine various issues related to data protection in India. Okay. In July 2017, a committee of experts chaired by Justice B.N. Sri Krishna, okay, was set up to examine various issues related to data protection in India. A committee of experts was constituted. This was a 3-member committee, I must tell you. This was a 3-member committee, and this 3-member committee was chaired by Justice B.N. Sri Krishna. This was set up to examine various issues related to data protection in India. The committee submitted its report along with a draft Personal Data Protection Bill 2018 to the Ministry of Electronics and Information Technology in July 2018. The committee submitted its report along with a draft Personal Data Protection Bill. Actually, this draft of Personal Data Protection Bill was prepared by the Justice B.N. Sri Krishna Committee. Okay. Was set up to examine various issues related to data protection in India. The committee submitted its report along with a draft Personal Data Protection Bill 2018 to the Ministry of Electronics and Information Technology in July 2018. Okay. The statement of objects and reasons of the Personal Data Protection Bill 2019 states that the bill is based on the recommendations of the report of the expert committee and the suggestions received from various stakeholders. Okay, so this committee submitted its report with a draft. Which draft? The draft Personal Data Protection Bill 2018. And it submitted this report along with this new draft Personal Data Protection Bill 2018 to the Ministry of Electronics and Information Technology in July 2018. The statement of objects and reasons of the Personal Data Protection Bill 2019 states that the bill is based on the recommendations of the report of the expert committee and the suggestions received from various stakeholders. How is personal data regulated currently? Currently, the usage and transfer of personal data of citizens is regulated by the Information Technology Rules 2011. Okay, now you have to understand this. We have already discussed this Monday. We discussed the Information Technology Intermediary Guidelines and Digital Media Ethics Code Rules 2021. Okay, which have replaced the Information Technology Rules of 2011 under Section 87 of the Information Technology Act 2000. Okay, the usage and transfer of personal data of citizens was regulated by the Information Technology Rules 2011, and now it is, you have to make sure that you understand this, that it was regulated by the Information Technology Rules 2011, and now it is going to be regulated by the Personal Data Protection Bill. Okay, some important facts which cannot be separated from the digital media are already there in the Intermediary Guidelines and Digital Media Ethics Code Rules of 2021. But a separate law has been legislated and made called the Personal Data Protection Bill, so that the issue of privacy of personal data is separately dealt with and properly dealt with. Okay. So currently, up till now, the usage and transfer of personal data of citizens was regulated by the Information Technology Rules 2011 under the Information Technology Act 2000. Okay, are you getting my point? इसमें कोई परेशानी? Albeit 2011 rules have been replaced, have been removed, and in place of the 2011 rules, what has come? The Information Technology Intermediary Guidelines and Digital Media Ethics Code Rules 2021. And the central government has the power to make these rules under Section 87 of the Information Technology Act 2000. It's written here under the IT Act 2000. Okay. The rules of 2011 were also framed and made and enforced under Section 87 of the IT Act 2000, and the very recent Intermediary Guidelines and Digital Media Ethics Code Rules 2021 have also been framed and enforced under Section 87 of the IT Act 2000. Do you have any question up till here? Any question? Okay. Now the rules hold the companies using the data liable for compensating the individual in case of any negligence in maintaining security standards while dealing with the data. Like every government agency or any private agency on the web today, if it is seeking your personal data and you are already submitting, like we have already submitted to our personal details to so many institutions on the internet, right? Now, every company, listen to me very carefully. Every company which is using our personal data is liable for compensating us in case it commits any negligence in maintaining the security standards while dealing with the data. They have to create their and maintain their security standards, data security standards. If there is any negligence while maintaining their security standards and our data gets leaked by them, either by negligence or by an intentional, with an intentional purpose, then they will have to compensate us. Okay, the companies using our data would be liable for compensating the individual in case of any negligence in maintaining security standards while dealing with the data. This liability was contained in IT rules of 2011. Okay, the expert committee in its report held that while the IT rules were a novel attempt at data protection at the time they were introduced, the pace of development of digital economy has shown its shortcomings. The expert committee, the Justice B.N. Sri Krishna committee, the three-member committee which was constituted in July 2018 to suggest some measures regarding the privacy of data, personal data, it also suggested and found that the IT rules of 2011 have become outdated, albeit at a time when they were framed, it was a novel concept and they were quite relevant at the time when they were framed. But now the pace of development of digital media and the growth of the digital economy and the growth of the technology has made them outdated completely. So the pace of development of digital economy has shown the shortcomings of the 2011 rules. For instance, the definition of sensitive personal data under the rules is very narrow. Obviously, whatever technology was there in 2011, like 11 years back, or 10 years back, or 9 years back, everything was contained within the definition of sensitive personal data. But now there is an excessive dependence on technology. We are using every minutest details of ours on the online things, in the online activities and in the online transactions. So the definition of sensitive personal data has to be widened now. Okay, so whatever had existed up till 2011 was covered within the definition of sensitive personal data, but with the passage of time and with the development of new technology, the definition of sensitive personal data has become quite narrow. And some of the provisions can be overridden by a contract. Okay, there were some provisions, like there was a provision in the IT rules 2011 that if you have submitted your details, if you have already submitted your private information or private details to somebody, and for doing something in lieu of something, and you have already entered into a contract, then you cannot get your privacy right enforced, because you have already submitted to the terms and conditions in lieu of getting something back to you from the person who was collecting your information. So there were some shortcomings and handicaps that the IT rules 2011 suffered from. So there was a definition of sensitive personal data under the rules has become narrow, and some of the provisions can be overridden by a contract. Further, the IT Act applies only to companies and not to the government. The IT Act 2011 applied only to companies and it did not apply to the government. What do you think? That it should any such rules or any such law should apply to the government also, or it should not apply? What do you think? What is your suggestion? What is your suggestion? What do you think? Any such law? What do you think? Any such law like the IT Act of 2011 or any such law should also make government liable, should also make, along with the private companies and private entities, should also make government liable for compensating the individual in case of any breach of personal data? So everybody is saying, most of you up till now, like Naman Sharma is also saying it should apply to the government. Jaspath is also asking to get them applied. Mohammad Riaz is also saying government should also be held liable, sir. Anakha is also saying it must apply to the government as well. Yes, it should apply to the government. You all are right. Like, I am also of the view that such kinds of rules and such kind of laws should apply to the government also. Because we have come across various things, like today, like in 2019, we were protesting against the CAA and the NRC. Many of us. And like, there are already some personal details with the government, lying with the government. Like, every one of us has already submitted our details with the government. What if the government uses those personal details against you to make you stop from protesting against the government? So this is what the government can do in some cases. So the IT Act applies only to companies and not to the government. Was one of the biggest flaw. Okay, so what does the Personal Data Protection Bill provide? The bill regulates personal data related to individuals and the processing, collection and storage of such data. Under the bill, a data principal is an individual whose personal data is being processed. Okay, the bill regulates personal data related to individuals. Like, it regulates personal data, simple, personal data related to individuals, and the processing, collection and storage of such data. And the processing, collection and storage of such data. Under the bill, a data principal is an individual whose personal data is being processed. Under the bill, a data principal is an individual whose personal data is being processed. Who is a data principal? Make sure you read the PDF doc or listen to me very carefully. I am reading each line. Under the bill, a data principal is an individual whose personal data is being processed. The entity The entity or individual who decides the means and purposes of data processing is known as data fiduciary. Okay, the bill governs the processing of personal data by both government The bill governs the processing of personal data by both government and companies incorporated in India. It also governs foreign companies if they deal with personal data of individuals in India. Now there is a question. Where that data residency is not in India, does it apply to those as well? Your question is answered here in the last line. It's already answered. Read the last line of the PDF doc. Look at the cursor. Read the last line. It also governs foreign companies if they deal with personal data of individuals in India. Like, personal data protection bill is now a comprehensive law, okay, that defines who is the data principal. Data principal is a person or an individual whose personal data is being processed. Like, if I have submitted my information and my personal data is being processed to be stored somewhere and to be used at a certain point of time, then I am the data principal, right? Whose personal data is being processed. The entity or individual who decides the means and purposes of data processing is known as data fiduciary. Like, the person to whom you are submitting is data fiduciary. Have you also understood the meaning of fiduciary? You must have read and learned what is a fiduciary relationship in a contract law. In the contract law, fiduciary relationship is also important part of it. Okay, data fiduciary, because a relationship of trust, like advocate client, like doctor patient, is a fiduciary relationship. Okay, so any person to whom you are submitting your data will be known as data fiduciary, because he is going to decide about the means and purposes of data processing. The bill governs the processing of personal data by both the government and companies. Like, it has overcome all those flaws which were there in the IT rules of 2011. It did not apply to the government, it only applied to the companies. But the personal data protection bill applies to both the government and the companies incorporated in India. Okay. It also governs foreign companies if they deal with personal data of individuals in India. Like, there was a question right now that where data residency is not in India, does it apply to those as well? It says it also governs foreign companies. It also governs foreign companies if they deal with personal data of individuals in India. Okay, will individuals have rights over their data? Will individuals have rights over their data? Now, another caption. The bill provides the data principal with certain rights with respect to their personal data. Like, every individual has a right over their data. You also have a right over your data. I also have a right over my data. Okay. These include seeking confirmation on whether their personal data has been processed, seeking correction, completion or erasure of their data, seeking transfer of data to other fiduciaries, and restricting continuing disclosure of their personal data if it is no longer necessary or if consent is withdrawn. Any processing of personal data can be done only on the basis of consent given by data principal. Any processing of personal data can be done only on the basis of consent given by the data principal. Like, you are the data principal, you have certain rights regarding your personal data. Okay, your confirmation will be sought. Okay, whenever your personal data will be processed and your confirmation will be sought. Okay, you can seek correction in your personal data. You can seek completion or erasure of your data. If you want your data to be erased or some data to be erased, you can get it done. Okay, you can also seek transfer of a data to other fiduciaries. Like, if you are not trusting one data fiduciary, you can get it transferred. You can get your data transferred from that data fiduciary to other data fiduciary. Okay, and you can also restrict disclosure of your personal data. Okay, and if it is not, if you do not find it necessary, and if your consent is withdrawn, then in that case any processing of personal data can be done only on the basis of consent given by data principal. Like everything has to depend upon the consent. But let me explain you one thing very clearly. Once you have consented to do something and everything has, like, your information gets spilled, like your information gets spilled, then you cannot claim then right over your data, because you have already consented to, like, spilling your personal informations, and once it got spilled and it reached to many of the people in the world and in the society, then you cannot claim that my privacy was violated by this particular data fiduciary, and you cannot take actions because you had already consented to such thing. But make sure that before everything is being done, your consent and your confirmation has to be sought. Okay, are there any restrictions on processing of an individual's data? The bill provides for certain obligations of data fiduciaries with respect to processing of personal data. Okay, there are some certain obligations of data fiduciaries with respect to processing of personal data. Such processing should be subject to certain purpose, collection and storage limitations. Okay, certain purpose, like every data fiduciary has to process and store the data for a certain purpose. You can't do it without any purpose. You have to collect and store it in a limited, like in a limited quantity, in a limited limited information has to be collected. For instance, personal data can be processed only for specific, clear and lawful purpose. It has to be specific, clear and lawful purpose. Additionally, all data fiduciaries must undertake certain transparency and accountability measures, such as implementing security safeguards and instituting grievance redressal mechanism to address complaints of individuals. Like every data fiduciary which is processing and storing your personal data has to undertake certain transparency and accountability. Like you have to, okay, every data fiduciary has to undertake certain transparency and accountability measures, such as implementing security safeguards and instituting grievance redressal mechanism to address complaints of individuals. Certain fiduciaries would be notified as significant data fiduciaries based on certain criteria, such as volume of data processed and turnover of fiduciary. These fiduciaries must undertake additional accountability measures, such as conducting a data protection impact assessment before conducting any processing of large-scale sensitive personal data. Includes financial data, biometric data, caste, religion or political beliefs. Okay. Certain fiduciaries would be notified as significant data fiduciaries. कौन से डेटा फाइड्यूशरीज सिग्निफिकेंट डेटा फाइड्यूशरीज कहलाएंगे? जिनके ऊपर बहुत ज्यादा वॉल्यूम ऑफ डेटा कलेक्शन की जिम्मेदारी है, या जिनका काम ऐसा है कि उन्हें बहुत सारा डेटा कलेक्ट करना है और बहुत सेंसिटिव डेटा कलेक्ट करना है, लाइक फाइनेंशियल डेटा, बायोमेट्रिक डेटा, कास्ट, रिलीजियस और पॉलिटिकल बिलीव्स. Okay, so these fiduciaries must undertake additional accountability measures. जिनके पास जो significant data fiduciaries है, उनको additional accountability measures लेने हैं, such as conducting a data protection impact assessment before conducting any processing of large scale sensitive personal data. Okay. What is the grievance redressal mechanism if the above restrictions are not followed? Like, for example, if above restrictions are not followed, and if, for example, the data fiduciaries are not undertaking accountability measures or transparency measures, then how will your grievance be redressed? To ensure compliance with the provisions of the bill and provide for further regulations with respect to processing of personal data of individuals, the bill sets up a data protection authority. Where will you go? You will go to Data Protection Authority. The authority will be comprised of members with expertise in fields such as data protection and information technology. Okay, authority के अंदर कौन कौन होगा? जो experts होंगे इस field के. और इंफॉर्मेशन टेक्नोलॉजी के. Any individual who is not satisfied with the grievance redressal by the data fiduciary can file a complaint to the authority. Orders of the authority can be appealed to an appellate tribunal. Appeals from the tribunal will go to the Supreme Court. This is very simple. Very simple. Any individual who is not satisfied with the grievance redressal by the data fiduciary can file a complaint to the authority. Okay. And if you are not satisfied with the orders of the authority, you can go to the appellate tribunal. If you are not satisfied with the appellate tribunal, you can go to the Supreme Court. Okay. Are there any exemptions to these safeguards for processing of personal data? Processing of personal data is exempt from the provisions of the bill in some cases. For example, the central government can exempt any of its agencies in the interest of security of a state, public order, sovereignty and integrity of India, and friendly relations with foreign states. Processing of personal data This bill is for IT Act 2000 only or any other law? This is a separate bill. It has nothing to do with the IT Act 2000. Processing of personal data is also exempted from provisions of the bill for certain other purposes, such as prevention, investigation, or prosecution of any offense, or research and journalistic purposes. Further, personal data of individuals can be processed without their consent in certain circumstances, such as if required by the state for providing benefits to the individual, 2, legal proceedings, and 3, to respond to a medical emergency. Okay, in some cases, the personal data processing can be stopped. Okay, but the government can use this personal data of individuals in certain circumstances, such as if it is required by the state for providing benefits to the individual. Like, for example, many informations like, have you, do you know anything about Pradhan Mantri Jan Dhan Yojana? The first Yojana that was introduced by the Modi government when they came to power in 2014, Pradhan Mantri Jan Dhan Yojana. All the bankless people, like who were not associated with banks, all the poor class who did not have their saving bank accounts in the banks, were made to open their saving bank accounts at zero amount, and their account details were taken and their accounts were linked with their Aadhaar card. And there was introduced a mechanism called DBT, direct benefit transfer, DBT. Okay, DBT, direct benefit transfer was introduced. Like, for example, मनरेगा, महात्मा गांधी नेशनल रूरल एम्प्लॉयमेंट गारंटी एक्ट के अंतर्गत, उसके अंडर, the unemployed laborers were used to, they were given 100 days of employment. Okay, and there were many other yojanas. Where the poor people would get some amount of money for a certain purpose. So earlier cash used to be given, but now there's direct benefit transfer. All those accounts which were made to be open under the Pradhan Mantri Jan Dhan Yojana, and they were further later on linked with their Aadhaar cards, were to receive all the cash directly from the government. So that's how the state uses some personal data for the benefit of the individual. Exactly, this is what is written in point 1 here, that personal data of individuals can be processed without their consent in certain circumstances. Like, it was compulsory, it was mandatory for each individual to get their saving bank accounts linked with the Aadhaar card, so that there is no duplicity or there is no fraud committed, because one person cannot open 2 accounts for taking benefits by becoming 2 different persons or by impersonating a different person. Okay, so that's how sometimes, like in certain circumstances, the personal data is used for the benefit of the individual. If required by the state for providing benefits to the individual. 2, if it is required in legal proceedings. 3, to respond to a medical emergency. Okay, then is the bill different from the draft bill suggested by the expert committee? Like, this is like one of the political debates. The bill has made several changes from the draft bill. For instance, the bill has added a new class of significant data fiduciaries as social media intermediaries. These will include intermediaries with users above a notified threshold, which enable online interaction between users. Okay. These will include intermediaries which enable online interaction between users. Further, the bill has expanded the scope of exemptions for the government, and additionally provided that the government may direct data fiduciaries to provide it with any non-personal or anonymized data for better targeting of services. Okay, that's it. सिग्निफिकेंट डेटा फिड्यूशरी किसको बनाया गया है? सोशल मीडिया इंटरमीडियरीज को बनाया गया है, जो सबसे ज्यादा ऑनलाइन इंटरैक्शन करवाती हैं यूजर्स के बीच में, उनको सबसे बड़ा डेटा सिग्निफिकेंट डेटा फिड्यूशरी बनाया गया है. दे हैव बीन मेड सिग्निफिकेंट डेटा फिड्यूशरीज. The social media intermediaries have been made significant data fiduciaries because of the excessive personal data they contain about an individual, and they enable online interaction between users. Like if you are chatting with somebody, like WhatsApp, your messages are supposed to be end-to-end encrypted. Nobody, no, not even the WhatsApp CEO himself can read your chats. Okay. What is GDPR? Xenia Potter is asking, in comparison to GDPR, how strict this system is on a scale of 1 to 10. I'm not getting your question. What is GDPR? Please. You have to tell me. Xenia Potter is asking, in comparison to GDPR, how strict this system is on a scale of 1 to 10. I'm not getting your question. What is GDPR? Please. You have to tell me. Any other question? Your questions are welcome. Okay, General Data Protection Regulation. So, General Data Protection Regulation is what? Where it comes from? I have not read anything about General Data Protection Regulation. I don't know. I'm sorry. I cannot answer this. Any other question? Yes, Ankita, it's a separate bill. It's a separate bill. Don't link it with the IT Act 2000. It's a separate bill. So I guess No more questions are there, and I'm ending the live stream now. Hope to see you tomorrow. Okay.